Hey everybody, this is Attorney Kenneth Stevens from the law firm Stevens PLLC, and today I want to talk to you all about dispute resolution clauses, specifically in government contracts. So, when you're doing business with different government entities, obviously, and even on the private side, you'll look in the agreements, and normally there's a clause in there that's very specific about how any kind of dispute between the parties is going to be resolved. In a lot of public contracts and even private contracts, you'll have an arbitration provision in there, and it'll say, hey, you have to submit your claim by a certain amount of time, and mediation is like a condition precedent, and then you can file a claim for arbitration. Or if you're in the public side, you'll see sometimes, like if you're doing business with like a county or something like that, it'll say, just file in a court of competent jurisdiction. But one thing that a lot of contractors don't think about, and that is often overlooked, is that if you're doing business with the state or like an entity of the state, for example, like a university, oftentimes there's reference to a dispute resolution process that's codified by statute. It's under the Texas Government Code, Section 2260. And that section is very specific and outlines what happens in the event of a dispute between the parties. It's nothing like the regular litigation process, nor is it anything like your typical arbitration proceeding. Under 2260, you have to submit a claim. You only have 180 days to give your notice, and then a representative from the state pretty much analyzes the claim and negotiates it, and then you can request a hearing after a certain amount of days. I believe it's like 270 days. You can request a hearing, but it's just an administrative hearing, and it's with the State Office of Administrative Hearings. So it's not even like a process through the courts or a process through like an arbitration panel. It's actually an administrative procedure. A lot of people don't know that. And so if you're doing business with a state entity, you need to be very careful. You need to understand what your remedies are in the event there's some kind of breach or you have some kind of issue. Because one thing that you have to know, again, is that you have to give notice within 180 days of your claim. And so if you let that thing drag out, you could be in a situation where you have no remedy. Secondly, that decision from the administrative hearing is not appealable except on like abuse of discretion, which is a really high standard. So it's a very limited right to appeal in that situation. So I say all that to say, if you're doing business with a state entity, like a university system or something like that, you need to really be careful, really understand what your remedies are, because you may be more limited than you think. Anyway, I hope this is helpful, and as always, happy building.